Good afternoon, ladies and gentlemen, our guest, Advocate Adams, participants, students, lecturers who tutored the students competing today, members of staff, and Northwest University staff members in general, members of the judiciary, attorneys, advocates, and the NPA. It is my pleasure to welcome everyone to the Northwest University Juta Mock Trial Competition Final 2021. The importance of mock trial cannot be overemphasized. In addition to providing students with knowledge of the judicial system, legal process, and courtroom procedures, mock trial teaches essential skills such as public speaking, critical thinking, and the art of forming a persuasive and cohesive argument. Trial advocacy, therefore, is a vital exercise for our law students, as it provides a transition from the study of law to the practice of law. It teaches one how to be a skilled and able litigator. We are also honored to have Advocate Adams in our midst, and he will share his practical experience with us. Advocate Adams hails from Promosa, a small township in Potchefstroom. He started his schooling career at Promosa Primary School and matriculated in 1992 as head boy at Promosa Secondary School. Advocate Adams started his tertiary education at the then Potchefstroom for Christian Higher Education, pursuing a BUris degree. He graduated in 1996. Because of a lack of employment opportunities, he enrolled for his LLB degree. In 1999, Advocate Adams started his career as an aspirant prosecutor in Pretoria. After a training period of 6 months, he was placed in the regional court in Johannesburg, where he worked in a specialized unit prosecuting all hijacking cases in Johannesburg. Due to the overwhelming success of this unit, the 3 prosecutors later had to deal with all the cases involving bank robberies too. After having worked 5 years in the regional courts, Advocate Adams was promoted to the rank of senior prosecutor and is also the tutor for the Northwest Province. Advocate Adams completed his LLB degree in 2003. In 2013, he enrolled for the LLM program at the Northwest University, as it is currently known, and attained his degree in 2016. Advocate Adams is currently studying towards his LLB degree in criminal law and procedure. We are honored to have you, Advocate Adams, in our midst. And with those few words, I would like to thank everyone for their participation this afternoon. And thank you for joining us as the Faculty of Law. And may the best team win. Thank you.
Court is in session. Is the state ready to proceed?
Indeed, Your Worship.
You may proceed, Mr. Prosecutor.
As it pleases the court, Your Worship, the case before this Honorable Court today is case number 134 of 2021. Presiding officer is Advocate Mark Adams. State prosecutors Jacob Masumpa, Lutando Swartz, Raymond Van Pieren, and Tato Mutigwe. The defense attorneys are Olani Masango, Oli Trekiso, Jailin Mutobi, and Kamo Kopuza. For the purposes of this case, Your Worship, there is no interpreter will be used. The case is on the roll to trial today. The accused was released on bail. The accused is Josephias Piri, and the accused is present in court today. If it pleases the court, the state is ready to proceed with the case.
You may proceed, sir.
As it pleases the court. Annexure 1, case number C-134 of 2021, the state versus Josephias Piri, hereinafter called the accused. The accused is charged in that upon the 3rd of November 2017, a protection order was granted by a magistrate in Potchefstroom, in the district of Potchefstroom, between the accused and Ellen Piri, in terms of which the accused was ordered not to do the following: not to commit the following acts of domestic violence: harass, intimidate, insult, assault, or threaten with violence, and any other act of domestic violence; not to enlist the help of another person to commit the acts of domestic violence specified in paragraph 1 supra, and that the protection order was duly served on the accused on the 3rd of November 2017, and it is still valid. That on or about 15th May 2021, and at or near 2231 extension 7 Ikageng in the district of Potchefstroom, the accused did unlawfully and intentionally break the conditions mentioned in the protection order by harassing the complainant, intimidating the complainant, threatening the complainant with violence, insulting the complainant, and assaulting the complainant with the intent to do grievous bodily harm by having stabbed the complainant. If it pleases the court, the state would like to hand out the charge sheet.
Thank you, Mr. Masumpa. Mr. Akiers, can you hear me?
Yes, Your Worship.
Do you understand the charge leveled against you?
Yes, Your Worship, I do understand.
How do you plead to this charge?
I plead not guilty.
Thank you. The defense may proceed.
Thank you, Your Worship. My name is Mutobi Joylene. I'm here with my co-counsels, Kolisile Tekiso, Olane Masango, and Kamukupuza. We are the defense and will be representing the accused, Mr. Piri Sophia. I confirm that Mr. Piri's plea is in accordance with our instructions. We as the defense will not be presenting any plea explanation. We will be leaving it in the hands of the state to prove all elements beyond reasonable doubt.
Mr. Piri, do you confirm that?
Yes, Your Worship, I do confirm.
Thank you. The accused may be seated during the proceedings. Mr. Prosecutor, you may proceed.
As it pleases the court. Your Worship, the state would like to address the court in terms of section 150 of the Criminal Procedure Act 51 of 1977. The case before the Honorable Court is that of assault. The onus rests on the state to prove all elements of this crime beyond reasonable doubt. As the elements are already known to the court, the state begs for the indulgence of the court in this regard. The elements of the said crime are as follows: the unlawful and intentional application of violence or threat of violence, As it pleases the court, the state will call one witness, Ellen Peary, the complainant herself, through her testimony of the events that took place on 15th May 2021. The state will prove beyond reasonable doubt that the accused did unlawfully and intentionally assault the complainant, Mrs. Ellen Peary. If it pleases the court, the state hereby calls Ellen Peary to the stand.
The witness may enter the witness box. Ellen Peary.
Good day, Your Worship.
Ma'am, do you have any objections taking the prescribed oath?
No, I do not, Your Worship.
If you do not have any objections, do you then swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If you so swear, lift up your right hand and say, "So help me God."
So help me God.
Witness is sworn in, Mr. Masumpa. You may proceed.
As it pleases the court, Your Worship, Mr. Swartz shall proceed with chief examination.
Thank you, sir.
As the court pleases.
Good morning, Your Worship. As it pleases the court, Your Worship, the state would now like to proceed with its evidence in chief.
You may proceed, sir.
Thank you, Your Worship. Good morning, Mrs. Fee.
Good morning.
Mrs. Fee, do you know as to why you are here today?
Yes, I do.
Could you please tell the court as to why you are here today?
On the 15th of May, 2021, at around 11:30 in the evening, the accused came to my house, drunk, and he intimidated me, as well as verbally and physically assaulted me, and telling me that a piece of paper does not matter to him.
Where do you live?
Excuse me?
Where do you live? Where do you currently stay? Where do you reside?
I live at 2231 Extension 7, Ikageng, Potchefstroom.
With who do you reside there now?
I used to live with my husband. But since I got the protection... Excuse me?
You said you live with your husband. You care to elaborate on that?
Yes. I used to live with him since I got the protection order against him in 2017. We no longer live in the same house. I live in the main house and he lives in a back room on the yard.
Thank you. Do you mind describing to the court your yard plan?
Excuse me?
Do you mind describing to the court your yard?
It is
Your
the
yard
gate.
plan.
Yes, it is the gate, then the main house, and then at the back of the yard, it is the back room where my husband resides.
Thank you. Your Worship, may the record please reflect that the client just testified as to the yard plan in which she lives in with the accused.
So noted, sir. You may proceed.
Thank you, Your Worship, as it pleases the court. Ms. Feedy, what is your relation to the accused?
He is my husband.
Is the accused in court today?
Yes, he is.
Do you mind just pointing out to the accused for the court, please? Do you mind identifying the accused, please?
No, I don't.
Objection.
You may proceed with your objection.
The identity of the witness has already been, the identity of the accused has already been established, Your Worship.
Mr. Swartz, do you wish to reply to that?
Your Worship, if I may reply to that.
You may,
Mr. Van Vieren.
Your Worship, they have not delivered any plea explanation, so the identity of the accused has not been established, Your Worship. Hence the importance of having Ms. Ellen Ferry point out the accused, Your Worship.
So noted, the court will allow the state to lead evidence with regards to the pointing out or the identification of the accused. You may proceed, sir.
Thank you, Your Worship. As it pleases the court. Mrs. Fury, can you please identify the accused for the court today?
Yes. He is wearing a dark shirt with no hat.
Thank you, Your Worship. Thank you, Mrs. Fury. Your Worship, may the record please reflect that the complainant just identified her husband as being the person who assaulted her on 15 May 2021 exactly at 11:30 and being the person who assaulted her and being the accused in question. Thank you, Your Worship.
The court notes the identification of the accused person as the person who is married to the witness. With regards to the other information that you've indicated, sir, some of them has already been placed on record, but maybe you might want to lead the witness with regards to the others. You may proceed, Mr. Swartz.
Thank you, Your Worship. Mrs. Fury, prior to this incident, were there any other incidents of assault that you suffered at the hands of the accused?
Yes, there were incidents like this since 2015.
Did you take any other measures before resorting to the before resorting to the order, the protection order?
Yes, I did. I tried to involve family and friends to help resolve the issue, but it was to no avail.
Thank you. When did you receive the protection order?
The first time it was issued was on the 1st of September 2017.
What type of protection order was this?
It was an interim protection order.
Was it served on the accused as well?
Yes, according to my knowledge, it was.
Did the accused appear for the hearing of the interim protection order?
No, he did not.
When the accused did not appear for the hearing of the interim protection order, what was the court's decision regarding this?
The court saw it fit to transfer the protection order from an interim protection order to a final protection order.
Okay. Your Worship, may the state please may the state please present the complainant with a copy of the protection order, so that she can confirm as to that this was indeed the protection order that she did receive.
You will proceed and do so, Mr. Swartz.
Thank you, Your Worship. Mrs. Feely, the protection order in question. Thank you. Mrs. Feely.
Yes.
The protection order in question, is this more or less, is this indeed the protection order that was served upon you? That was served upon the complaint, upon the accused. Thank you.
Yes.
Sorry. Thank you. Okay. After the protection order was granted to be a final protection order, was a warrant of arrest issued for this?
Yes, there was.
Your Worship, as it pleases, Your Worship, may the record please reflect that the protection order and the warrant of arrest that the accused just mentioned here today is indeed the one that is displaying currently, which was presented to the complainant as well as the defense as well, Your Worship. May the record just reflect that.
So noted, sir. You may proceed.
Thank you. What were you doing prior to the incident, Ms. Feely?
Prior to the incident, I was sleeping.
Were you of sober mind prior to sleeping?
Yes, prior to the incident, I was of sober mind. I was watching TV and called my children to check up on them, as I do every other night.
Were there any other people with you in the household?
No, there wasn't. I live alone as both my children are adults.
When you told the accused at the door to leave, what happened there afterwards?
The accused screamed and insulted me. He threatened me with violence and said that he would break down the door if I did not open it.
How did this make you feel, Ms. Field?
It made me feel very, very scared and vulnerable at the moment.
What made you realize that it was the accused at your door?
I recognize his voice since we were married for so long, so I know his voice like the back of my hand.
What indicated to you, as mentioned earlier, that you stated that the accused was drunk? What indicated to you that the accused was drunk?
When the accused spoke to me, he spoke in a slurred speech, which is how he usually speaks when he's drunk.
Who had access to your house?
Only me and the accused. Me and the accused.
Thank you. What proceeded to happen once he told the accused to go away, as you will call the police?
He kept on banging on the door and screaming. He said that he wanted to show me that paper isn't much to him or doesn't mean much to him.
According to your knowledge, who else carried any knowledge of the protection order?
To my knowledge, it was only me and the accused, since it was very emotional for me because I didn't want other people to know, or the people around us to know, that our marriage was going through such a rough patch.
According to your knowledge, Ms. Williams, could you think of anyone who would possibly attack you?
No, because I have good relationships with everyone around me except the accused. He has harbored hatred for me ever since I got the protection order against him, and uses every opportunity he gets to verbally abuse me and verbally assault me to make me feel guilty for getting a protection order against him.
Did you report any of these incidents thereafter?
No, I did not, because they were not as severe as the current one.
Earlier you mentioned that the accused had a key to your household. How did the accused get access to your house?
Firstly, he tried to open the locked door with the key, but since he was drunk, he was unsuccessful, and I heard the key fell to the door. He then after proceeded to bang and kick on the door and broke the lock part of the door, and thus gained entry to the house.
Where were you when the accused entered the household?
I was hiding behind the sofa in the living room.
Were your lights on or off at this time?
They were off.
Was it dark in your household?
It was dark, but it was not that dark. I could still make the outline of furniture and objects around me.
What happened afterwards?
After the accused came into my house.
Yes, ma'am.
When he entered the house, I realized that I needed to exit immediately. So I ran for the front door past the accused, but he managed to grab me by my right shoulder. That caused me to get a pinching sensation into my right shoulder.
Thank you, sir. Could you please describe to the court your house plan?
My house plan is when you enter the front door, it is the living room. At the back, it is the bedroom, then bathroom, and beside all this is the kitchen.
Thank you. Were there any other exits within your household?
No, the front door was the exit.
Could you please describe to the court as to the position which you were in when you were pulled back by the accused?
I was in front and the accused was behind me, pulling me back.
You mentioned earlier that you had a sharp pain in your right shoulder. What was
Yes.
the cause of the sharp pain in your right shoulder?
It was the cause from where the accused grabbed me from behind.
Did you see any weapon on that given day? From the accused?
Yes, I did.
How did you see it?
As I was struggling to get free and get out of the grasp of the accused, I saw a weapon at the corner of my eye, out of the corner of my eye.
You mind describing to the court this weapon that was used?
It was a long, sharp, shiny object, almost like a knife.
According to your knowledge, was this weapon used that evening?
Yes, seeing as I had a stab wound on my left shoulder.
According to your knowledge, could there be any other reason besides the stabbing which you suffered at the hands of the accused, which might have caused this injury on your shoulder?
No.
Could you please just show to the court where you were stabbed?
I was stabbed right here on my left shoulder.
Your worship, may the record please reflect that the complainant just testified as to where she was stabbed and where she sustained the injuries at the hands of the accused.
The witness is gesturing, reaching towards the back of her left shoulder, trying to indicate where she was stabbed. So noted, sir. You may proceed.
Thank you, Your Worship. Ms. Firi, how did you manage to get out of the house?
As I was struggling towards the front door, I managed to untie my gown and pulled free from it. Then I ran towards the front. Well, while I was pulling free from it, the accused stumbled, which gave me the opportunity to run to the front door.
What happened outside?
As I went outside, I slipped on the ground and obtained skid marks on both my knees.
What happened after obtaining the skid marks on your knees?
After that, I saw a SAPS vehicle patrolling the streets, so I immediately ran to them and begged them for help.
How did the police officer see the person, the accused, leaving the house?
No, they did not, as he was standing with his back towards the house.
Ms. Fili, why did you not fight back during that altercation inside?
I did not fight back because I'm a 45-year-old frail woman, so the accused could easily overpower me, and seeing as I had already sustained injuries, it would make it even more difficult for me to fight back.
Your Worship, the state, we would like to present Ms. Fili with a copy of the J88 so that she can attest to the injuries that she sustained does indeed correlate with that of the medical practitioner.
You may proceed, but perhaps you might want to ask some introductory questions with regards to the J88,
yes,
sir.
Yes, Your Worship. Your Worship, we are hearing it. Ms. Fili, prior to, after this incident, did you go and see a medical practitioner for the injuries that you sustained?
Yes, I did.
Your Worship, may we now please present the complainant with the J88 so that she can correlate and attest to the injuries that she sustained that day was indeed due to the fact that the injuries that she sustained on the given day.
You have the opinion that you've asked enough introductory questions. You may proceed to do so, sir.
Thank you, Your Worship. As it is the court, we would now like to present the complainant with the J88. Thank you. Ms. Fili, is this indeed the J88 that you were presented with at that specific point in time, the once you were examined by a medical practitioner?
Yes, it is.
Thank you, Ms. Fili. We are just going down with it currently. Thank you. Ms. Fili, in front, Ms. Fili, the injuries sustained here, does it indeed correlate with the injuries that you sustained on the given day?
Yes, it does.
Thank you, Your Worship. Your Worship, may you just be proven that the J88 form and the injuries that the accused suffered on the given day does indeed correlate with one another.
So noted, sir.
Mrs. Fili, what confirmation did you get that indeed it was the accused in question on that given day at your household?
Firstly, I recognized his voice. Like I said, we were married for a very long time, so I could recognize his voice very easily, as well as his figure when I saw him running out of the house, and when I saw his shadow in the house. He has also every motive to attack me, and he also used the words that the piece of paper means nothing to him, which is words he usually uses when he verbally assaults me.
Thank you, Your Worship. The state has no further questions for the witness.
The defense may proceed with cross-examination.
Thank you, Your Worship. Just a moment. Your Worship, the defense would like to proceed to lay the basis for the use of the complainant statement.
Proceed, sir.
As the court pleases. Mrs. Piri, did you make the statement to the police?
Yes.
Was the statement made in a language you understand?
Yes, it was.
Can you please tell the court which language was it?
It was in English.
Was the statement written by you personally?
Yes, it was.
Or it was written on your behalf?
No, it was written by me. It was written by
personally?
me. Yes.
Okay. Was the statement, did you understand what was read back to you?
Yes, I did.
Was the statement read back to you?
Yes.
Was the statement read back to you, ma'am?
Yes, it was.
Did you understand what was read to you?
Yes, I did.
Okay. Your Worship, the defense would like to present the statement to the witness.
You may proceed to do so, sir.
As the court pleases. Mrs. Piri, is this the statement you made to the police?
Yes, it was.
You confirm that this is the statement you made?
Yes.
Objection, Your Worship.
There's an objection. You may proceed with your objection, sir.
Your Worship, this question was asked and answered already on the second occasion.
Which question specifically, sir?
Your Worship, the defense has asked the complainant in this matter whether this is indeed her statement, and she has confirmed it, and then the defense proceeded to ask her again, is it her statement, when this is already a asked and answered question, Your Worship.
Do you want to reply to that, Mr. Masango?
My apologies, Your Worship. My network seems to be breaking up the site, hence I did not get the answer properly.
You mean the answer from the witness?
Yes, Your Worship.
That being the case, I'm going to allow you to proceed, sir. You may proceed to lay a basis and to ask questions relating to the statement that a witness would have deposed to.
As the court pleases. Is that your signature at the bottom, ma'am?
Yes, it is.
Thank you. Your Worship, the defense has laid the basis for the use of the witness's statement. If it pleases the court, we would like to continue with cross-examination.
You may do so, sir.
As the court pleases. Mrs. Piri, what did you do when you first heard the banging on the front door?
Firstly, I then shouted out and asked the person, well, rather told the person that they should go away.
Okay. Has the accused ever threatened you with violence since you were granted the protection order in 2017?
No, not prior to this incident, no.
Okay. Mrs. Piri, why did you not call your sister or the police when you heard the loud banging on the door in the middle of the night since you were alone?
Because at that time I was in such shock that I didn't think clearly, and all I could think is that I just wanted the person to go away. Hence, I shouted at them that they should go away.
All right. May I draw your attention to paragraph 4 of your statement in the last sentence?
Yes.
Do you know the meaning of the phrase slurred speech?
Yes, I do.
Can you please tell the court what it means?
Slurred speech means speech that is words that are mingled together so that the hearing or the hearing of slurred speech is made very difficult.
Okay. My sources define slurred speech in the following, and I'm going to ask you whether you agree or not.
Okay.
The meaning of the phrase slurred speech means poor pronunciation of words, mumbling, or a change in speed or rhythm during talking. Do you agree?
Yes, I agree.
Now, you testified that you recognized the accused's voice, even though the speech was very slurred. Is that correct?
Yes, it is.
Is it possible that you heard someone else's voice and confused it with that of the accused?
No, I do not think so. Like I said, me and my husband were married for very long, and I know how he is when he is drunk, and I can recognize his voice like the back of, well, I know his voice like the back of my hand.
Okay. You testified that you knew that the person behind the door was drunk. Is that correct?
Yes.
How did you know?
Because of the slurred speech.
So the slurred speech alone could have been the main reason that made you believe that the person behind the door was drunk?
Yes.
Thank you. May I direct you to paragraph 5, line 1?
Yes.
You refer to your attacker as the person trying to open the door. Is that correct?
Yes.
Further down in line 2, you refer to your attacker as Josephias, which is the name of the accused.
Yes.
Why do you suddenly change the manner in which you refer to your attacker?
Because I didn't think it would be necessary to write his name out the whole time. I thought that when I referred to the person, it would be obvious that I referred to him. As I said earlier in my statement, that I already knew it was him.
Did you in any way see his face and confirm that it was actually your husband?
No.
Does the accused still have access to the main house?
Yes.
Would I be wrong? Would I be right to say that the accused did not have to break the door if he still had access to the main house?
Yes, you would be correct.
So the person who attacked you on the night in question, how did he access the house?
By breaking the door after I heard the key that he had fell.
He had a key in his possession at the time.
Yes, I said earlier that I heard how he tried to open the door with the key, but because he was drunk, he was unsuccessful and therefore let the key drop, which I heard.
Thank you. Why were the door locks not changed after the accused moved to the back rooms?
Because the back room was that small, the accused still sometimes came into the main house to cook. So therefore he needed access to the house.
Okay. Why did you only threaten to call the police and did not just do it? Seeing that you may have been afraid of your life, for your life.
Because it was that late at night, I didn't want to cause that much trouble. So that is why I first gave him a warning to go away. And thereafter, I said that I would call the police.
Wouldn't you say it makes sense that any reasonable person being fearful for their life would just not think about any other thing but to just call the police?
Yes, but like I said earlier, in that moment, I was in such shock that I just wanted the person to leave. Therefore, I called out and asked him to go away.
Did you feel there was danger looming at the time?
Yes.
Okay. Is your husband employed?
Yes.
All right. I put it to you that since you were not sure about the identity of the person banging the door, you deemed it convenient that it was the accused because you were angry that he is unemployed. I put it to you that it is going to be the accused testimony that he is unemployed and he only survives by doing odd jobs. How would you respond to that?
Can you repeat the question?
A very loaded, before you proceed, then that's a very loaded question, sir. Can you please break it up? There's a number of questions in that question. I'm going to ask you to break it up, please, so that the witness can respond to it.
Do you want me to repeat the question, Ms. Piri?
Yes, can you maybe just break it up?
Okay. I put it to you that the accused will come and testify to this court that he is not employed and he survives by doing odd jobs. What is your response to that?
I don't agree with that.
Okay. I put it to you that since you were not sure about the identity of the person behind the door, you deemed it convenient to just say it was the accused because you were angry that the accused is unemployed. What is your response to that?
I also do not agree with that.
Any reason why you do not agree? Before you proceed, sir, ma'am, you keep on saying that you do not agree with it. Why do you not agree with it?
Your Worship, with the second question, I do not agree with it because, like I said earlier, I did identify the person behind the door as my husband because I recognized his voice.
Thank you, Mr. Masango. You may proceed.
As the court pleases. Do you know your husband's employer, Mrs. Piri?
No.
Your Worship, objection.
As an objection, you may proceed with your objection, sir.
The relevancy of this question, Your Worship.
Well, before I'm not even going to afford Mr. Masango an opportunity to reply to it. I suppose this question goes back to a question that was asked not so long ago, to the effect that a statement was put to the witness that the accused is unemployed and that he survives by odd jobs, to which the witness says she disagrees. And I assume Mr. Masango now wants to make a follow-up on that. So it is not directly related to the merits of the case, but I'm going to afford Mr. Masango to proceed with his line of cross-examination, but keep it to the point, sir.
As the court pleases.
Objection, Your Worship.
Is there another objection?
Yes, Your Worship.
You may proceed, sir. You may proceed with your objection.
Your Worship, this is an asked and answered question. The defense already placed a statement before the complainant, and the complainant said to already answered that the accused wasn't working, and therefore, knowing the employer of the accused would just prove to say that the complainant was unaware of the fact that the complainant did testify that the husband wasn't working. So therefore, this question was already asked and answered when she answered that the husband wasn't working.
As the court has indicated, this question most probably stems from the answer which was elicited from the complainant with regards to the second last question. The court made a ruling already. The court is going to make another ruling to the effect that Mr. Masango may proceed with his last question. You've asked a question as to whether the witness knows the accused employer, sir. You may proceed with your question.
As the court pleases. Mrs. Piri, do you want me to repeat the question?
Yes, please.
Do you know the accused employer?
No.
So how can you be sure that he is employed?
Because the last time, or in the bygone, because we do not see each other that much, the last, as to my knowledge, that I know is that he was employed.
Okay. How far from the front door is your bedroom?
It's not that far, about a few meters, because the main house isn't that big.
Thank you. Which door is the wooden door?
It is the front door. It's the one and only door exit in and out of the house.
So it is the very same door that was being banged on. Is that correct?
Yes.
In paragraph 8, line 2, you testified that you tried running out of the house. You used the front door. Is that correct?
Yes.
Why did you run to the front door?
Because that is the only exit in and out of the house.
So you deemed it safe for you to run out of the house, move past him because he is blocking the door, and instead of just staying in the house.
Yes, because I thought my chances of trying to run past him was bigger than my chances of hiding in the small house.
I see. At what time did you return to your house with the police?
I'm not sure.
Was the accused arrested around that time?
Yes.
Okay. You just testified that you deemed it safer for you to run out of the house. How is it that you ran out of the house, running past him where he was standing in front of you, but then you still managed to sustain injuries on your back? How is it that you sustained such an injury when you encountered such a person face to face and you did not give him your bag?
What happened was, when the door broke down, he already halfway into the house, and then I ran past him, and as I ran past him, he grabbed me by the back.
Mrs. Piri, you testified that you suspected it was the accused when you heard someone banging on the door. Is that correct?
Yes.
I put it to you that the accused will come and testify that you blame him for everything that goes wrong in the yard, which is why you instantly suspected that it was the accused who was banging on the door. What can you say about that?
Well, given to the history and the numerous incidents there was of assault against me by him, I assumed that it was a reasonable assumption of me to make. And by hearing his voice and recognizing his voice, I think that I made a reasonable assumption in identifying and knowing that it was him.
So you did not make any form of confirmation. You just assumed, you drew an inference.
Yes.
How is this court supposed to believe that your testimony is true and not falsified, when you cannot exactly identify the identity of the person who attacked you?
Mr. Masango, you need to be careful before you proceed, ma'am. You need to be careful, and I'm going to ask you to be a little bit more precise and succinct with your questions. You are saying that a witness cannot in any way identify the accused, if I understand you correctly, or that there was just an assumption that was drawn. You must remember, even though the witness might not have testified to the fact that she laid eyes on the accused person and that she had X amount of seconds or minutes to make a proper observation, the witness in so many words said that she heard his voice and that she has been married to him and that she recognized his voice. So when you say that there is no form of identity, are you also now referring to the fact that the accused might have been identified through his voice?
Such an identification process, Your Worship, is somehow flawed because the accused, the complainant testified that the person bringing the door spoke in a slurred voice, which was not a clear voice. It could have been anyone's voice to that effect, Your Worship.
Objection, Your Worship.
You may proceed with your objection, sir.
Your Worship, as the court pleases, it was stated within the examination chief of Miss Ellen Feary that they were married, they had children which are of a major age, so hence they were adults, and therefore it would be most probable for her to identify the voice of the accused. So opposing counsel is coming with a version where it is almost impossible for her to recognize the voice. I challenge that, Your Worship.
Your objection is noted, Mr. Van Vieren. I am not going to give Mr. Masango an opportunity to respond to your objection directly. Safe to say and safe to point out from the court's point of view and from the evidence placed on record already, the witness said that some of the words which were used are words that the accused normally used. The witness said that she's been married to the accused person for a number of years. The witness said that she recognized his voice, even though the speech might have been slurred. I'm back to the point, Mr. Masango. I think it is a very unfair statement to put to the witness that there was no form of identification. And when you want to challenge the witness on her identity or ability to make sense and to hear clearly the voice of the accused, you must do so, but do not put it to the witness that there was no identification. That is not in line with the evidence currently on record. You may proceed, sir.
As the court pleases. Mrs. Piri, can you please take a look at the J88 form?
Yes.
I put it to you that you sustained the abrasions on your knees when you fell trying to run out of the house because you are a frail person, according to the medical examiner's report. This statement of you being a frail person is noted on page 3, paragraph E of the medical examiner's report. What can you say about that?
I agree with it that I am a very frail person.
You agree that you are a frail person?
Yes.
Yes, and what do you say about the statement I just put to you?
Can you just repeat it again? I do not really understand the question.
I put it to you that you sustained the abrasions on your knees when you fell while trying to run out of the house because you are a frail person. What can you say about that?
About that, I say it is true because I fell to the ground after I was out of the house. I then slipped on the ground, which caused me to get the skid marks on my knees.
Thank you. The medical report shows an incision on your left shoulder blade, and you testified that you felt an extreme pain on your right shoulder blade. Can you explain the inconsistency there?
Yes. The pain that I felt on my right shoulder like I said earlier, was when the accused grabbed me from behind, he pinched me on my right shoulder. And with the stab wound on my left shoulder, at that moment, with all the adrenaline in my system and the still pinching sensation in my right shoulder, I did not feel the stab on my left shoulder.
So it is your contention that the pain you felt from the stabbing and the pain you felt from the stabbing are not equal, and that the pain you felt from the pinching was worse than the pain from the stabbing.
Objection, Your
Yes,
Worship.
because
Is it Mr. Van Vieren?
That is correct, Your Worship.
You may proceed with your objection, sir.
Your Worship, that was a compound statement to the complainant. So if you could maybe just break it up for the complainant, Your Worship.
Mr. Masango, I understand the question clearly, but there's a request that you break it up or make it simpler for the witness. Can you do so, sir?
As the court pleases. Mrs. Piri, you just testified that you did not the pain of the stabbing. From the pain of the stabbing and the pinching, which one was worse than the
I
other?
felt the pinch more because after the witness grabbed hold of me, I felt it. And then with that came such shock and the adrenaline that I just had to get out of his grasp, that when I got the stab wound on my left shoulder, I did not feel it.
I see. The medical reports on paragraph C4 states that you informed the examiner that you were attacked by your husband and he stabbed you with a knife or something sharp. Did you see the type of object?
No, as it was dark, but I was able to discern it, that it was a long, sharp, shiny object. And therefore, because it was shiny, it was easy to see in the dark.
So it is your contention that shiny objects are clearly visible in the dark?
Yes.
In paragraph 8, line 5, you testified that it was dark in the house. Is that correct?
Yes.
How then did you manage to view your face? That's if you did.
Just repeat that. You broke up towards the end. Just repeat your question, please, sir. It was dark in the house?
Yes, you testified that it was dark in the house. Is that correct?
Yes.
How did you manage to confirm that it was your husband's face in front of you?
Like I said, I was never able to see his face, and the house was dark, but it wasn't that dark. I could still make out the outline of objects and the furniture. And in the struggle, I saw his shadow and his figure on the ground.
It is the second time that the witness are uttering those words in the exact sequence, meaning that she already testified to that. I'm going to ask you to, I'm not curtailing your cross-examination, sir, but I'm not going to allow you or continue to allow you to ask questions which have been answered already. You may proceed with your cross-examination.
As the court pleases. You earlier testified that you were running out of the house. Did you actually manage to push him out of the way and then run as he was behind you by the time you got stabbed?
No, I never pushed him. When I ran past him before he injured me in any sort of way, I was already past him, and then he grabbed me and then proceeded the stabbing. So I never pushed him.
You never pushed him out of the way?
No, I ran past him. And then when I escaped, I was wearing a gown, and I untied the gown and then pulled myself free. And that is when he stumbled, and then I got the opportunity to run out of the door.
Okay, thank you, Mrs. Piri. Your Worship, the defense has no further questions.
Any re-examination?
Yes, Your Worship. As it pleases your worship, the state would now like to proceed with the re-examination. As it pleases your worship, the state would now like to proceed with his re-examination of the witness.
You may proceed with your re-examination, Mr. Swartz.
Thank you, your worship. Mrs. Phiri.
Yes.
Mrs. Phiri.
Yes.
Did you repeatedly tell the accused person to go away from your bed?
Yes.
How did you confirm that indeed it was the accused in question that day?
I'm sorry, can you just repeat the question?
How did you confirm that the accused in question was indeed the person at your house at that specific point in time being?
When
Objection.
Proceed with your objection.
Your worship, council's questions has been asked and answered regarding the identity of
Sustained.
the accused.
Sustained. You may proceed with any other questions, Mr. Swartz.
Thank you, Worship. Mrs. Phiri, to your knowledge, is your husband employed?
According to my knowledge, yes.
Objection.
There's an objection. You may proceed.
Council's question has been asked and answered.
Sustained. You may proceed, Mr. Swartz.
Thank you, Your Worship. Thank you, Your Worship. The state therefore has no further questions for the accused, and the state would like therefore close its case. But before it closes, the state rests its case, it would like to submit the J88 and also the protection order into evidence.
Wish to end them in as exhibits, sir?
Yes, Your Worship.
The court receives the J88 as Exhibit A. This document, I assume, is handed in terms of Section 212, subsection 4.
Yes, Your
It will
Worship.
be marked Exhibit A. The court also receives the protection order. This document will be marked Exhibit B, and it is a protection order issued in 2017, in which the accused was a respondent. The witness today was the applicant. As the court indicated, this will be received as Exhibit A. Mr. Swartz, please don't close your court. Don't close your case when the witness is still on the stand. Are you now done, sir, after you've handed up these exhibits?
Yes, Your Worship. The state would now therefore proceed to close its case.
Ms. Phiri, thank you for coming to court. Thank you for testifying. You are excused.
Thank you, Your Worship.
Mr. Swartz?
Your Worship, the state would now proceed to close its case. Thank you, Your Worship. And therefore, submit the J. Thank you.
State's case defense.
Thank you, Your Worship. If it is the court, the defense would like to call its only witness to stand.
The accused is Mr. Mpiri, is that correct?
Yes, Your Worship.
Do you have any objection taking the prescribed oath?
No, I don't.
If you do not have any objections, do you swear that the evidence that you're about to give will be the truth, the whole truth, nothing but the truth? If you so say and so swear, lift up your right hand and say, "So help me God."
So help me God.
Your witness is sworn in. You may proceed, ma'am.
If it pleases the court, Your Worship, I shall now hand it over to Ms. Tsekiso for the examination in chief.
Thank you.
Thank you, Your Worship. If it pleases the court, the defense would like to proceed with evidence in chief.
You may proceed, ma'am.
Right. Good afternoon, Mr. Piri. Can you please state to the court what you do for a living?
Good afternoon. I do odd jobs. I'm currently unemployed.
All right. And where are you currently staying?
I reside with my wife, but then I live at the back of the room.
And how long have you been living at the back of the room?
I've been living there ever since I was served with the protection order in 2017.
Okay, and since then, do you still have access to the main house?
Yes, I do, because I have my own keys towards the household.
All right, and how often do you go to the main house?
I don't go to the main house because I'll be contravening the protection order that was served against me. So I don't go there.
All right. Mr. Piri, where were you and what were you doing on the night of 15 May 2021?
On that day, I was home. I came home a bit late, but then around about 9 o'clock, I went to sleep.
All right. Mr. Piri, can you please tell the court about the incident your wife had you arrested for?
My wife had me arrested for contravening the protection order that was served in 2017. But I didn't contravene anything because I was asleep, and then the police came around about 1 o'clock the following day, and they had me arrested for that.
All right, so the police had you arrested for contravening the protection order. Is that what you're saying?
Yes, they said so to me.
Exactly. How exactly did you contravene the provisions?
Well, the complainant claimed that I verbally abused her, but at that time, I went to sleep. I never did that.
So just to confirm, Mr. Piri, you were asleep and the police then came to arrest you around 1. Is that what you're saying?
Yes, they came 1:30 a.m. It was that time.
All right. All right, Mr. Piri, since your wife got the protection order, have you ever threatened her with violence?
No, I haven't.
All right, have you contravened any of the provisions of the protection order since 2017?
No, I haven't.
All right, Mr. Piri, can you please tell us in detail about the incident that occurred on that night when you got arrested, or the morning rather?
Well, while I was asleep, there was a knock on the door, and then I asked the person to go away as I was asleep. And then the officer, and then the person told me that he is a police officer and he has a warrant to arrest me. So I said to him that the complainant has habits of phoning the police, as she always threatens me to do so, and she verbally abuses me and tells me that she'll call the police, and that she's always mad at me because I'm currently unemployed, and she blames me for everything that goes wrong in the household or the yard.
All right, sir. No further questions.
Cross-examination.
As the court pleases, Your Worship, the state would now like to proceed with cross-examination.
You may proceed, sir.
Thank you, Your Worship, as the court pleases. Good day, Mr. Piri.
Good day, sir.
Mr. Piri, can you confirm that you were issued with a protection order against you by your wife back in 2017?
Yes, I do confirm that.
And how did this make you feel?
I just responded to the way I was served with the protection order. I was not angry.
But I mean, surely, so if someone issues a protection order against you, you'd be concerned, you'd be angry because you did not do anything.
Well, at that time, as it pleases the court, I did testify that what I did was wrong, so I accepted all that.
All right, Mr. Fury. And then do you consider, with the protection order in mind, can you then confirm that you have a history of using assault?
I assaulted her in the past, but
before you proceed, sir, before you proceed, you have a history of what, Mr. Van Vieren?
Of using assault, Your Worship. And that is in alignment with, to substantiate that, Your Worship, that is in alignment with what the protection order stated, Your Worship.
Objection.
Yes, Mr. Masango.
Counsel is attacking the character of the witness.
Mr. Van Vieren, can you elaborate on the specific portion that you rely on or that you base your statement on? Where you say it is reflected that there is a history of assault.
Indeed, Your Worship. So back in 2017, before the issuing of the protection order, the court granted this in favor of the complainant, seeing that on the basis, I will quickly refer to the protection order, Your Worship, and that it was required, or what was asked of the complainant, of the accused, to not let's give you a second, Your Worship. It was asked of the accused to not harass, intimidate, insult, assault, or threaten the complainant with violence, Your Worship. So I'm basing that because the court has issued a protection order in 2017 against the assault that occurred in accordance with the evidence in chief presented by the complainant, Your Worship.
There is an objection currently to the effect that the state is trying to place character evidence on record. I've given Mr. Van Vieren an opportunity to indicate to the court where in so many words it is said or reflected that there is a history on the part of Mr. Fury, the accused person before court today, to assault a complainant. The court is not convinced that there is, in so many words, an indication that one can say or come to the conclusion just by looking at the protection order that Mr. Fury has such a history. I am therefore going to ask you, Mr. Van Vieren, to rather rephrase your question or to put it differently. This is almost like, you know, dealing with the accused SCP 69s before conviction. So the court has a good idea where you intend to go with your cross-examination, but maybe you can rephrase, especially in line of the fact that there is an objection to the wording or the phrase of your question as it stands. Thank you, sir. You may proceed.
Mr. Fury, Your Worship, I will attempt to rephrase the question as suggested by the court, Your Worship. Mr. Fury, in your understanding, why were you issued with why was a protection order issued against you in 2017 by your wife?
At that point in time, my wife felt that
Counsel's question
is there an objection? Come again, Mr. Masengu?
Counsel's question has already been asked and answered.
Doesn't.
I think what Mr. Van Vieren is trying to do is to adhere to the court's proposal or suggestion, and Mr. Van Vieren is also moving away from the very same point on which there was an objection to the effect that there's a history on the part of the accused to make himself guilty of assault. I think the question posed by Mr. Van Vieren is on point, and the court is going to allow him to put that question to the accused. You may proceed, sir.
Do you care to answer that question, or do you like me to repeat the question, Mr. Fury?
Can you please repeat the question?
In your understanding, why were you issued with a protection order against you in 2017 by your wife?
Well, at that point in time, my wife felt that I was verbally abusing her.
Okay, and I put it to you, Mr. Fury, that the protection order says, amongst other things, inter alia, that it's because you verbally assaulted, correct, as you've mentioned, and because you've assaulted the complainant. You care to respond?
Well, I verbally, yes, assaulted her in the past.
Mr. Fury, please to answer the question in full.
Can you just repeat that for me?
I'll repeat it again for the third time for you, Mr. Fury, that I put it to you that according to the protection order, yes, it states here that you indeed, and the protection order was issued because you indeed verbally abused the complainant and because you assaulted the complainant back in 2017.
Yes, I did.
Furthermore, Mr. Fury, why did you not attend why did you not make the court appearance when the protection order was issued against you?
I had to do odd jobs for my living, as I said earlier on.
Mr. Fury, but surely if you have a protection order against you, surely you'd attend to that first before you attend to other matters because of the serious nature and allegations against you.
I'm not against that.
Mr. Fury, I'll proceed. Mr. Fury, do you consider yourself to be a patient individual?
Yes, I do.
I put it to you that this is false because you lost your temper and you assaulted the complainant in 2017, which led to her having to issue a protection order against you. Do you care to comment, sir?
I don't understand your question.
There's objection, Your Worship.
The court can hear you. Thank you, Mr. Van Vieren. You may proceed with your objection, sir.
Counsel's question is irrelevant. It cannot be stated and proved that what happened in the past 20 years ago could still be the same reason as to what is happening today.
The court hears the objection. The court is going to overrule it. You may proceed, Mr. Van Vieren.
Thank you, Your Worship. Do you care to comment on that statement, Mr. Fury?
Sorry, I can't.
Sorry, Mr. Fury, I put a version to you. I'm going to repeat the version and I want you to comment if necessary on the version, okay? I put it to you that this is false because you lost your temper and assaulted the complainant in 2017, which led to her having to issue a protection order against you.
At that point, I did not lose my temper, but then we talked things and it was a heated argument between the two of us, so we're exchanging words.
Mr. Fury, after the enforcement of the protection order, you then voluntarily decided to build and live in the back room of the main house, correct?
Not correct.
Why?
I decided individually to go out because my wife and I were not in good terms.
And Mr. Fury, I put it to you that it is due to your reckless character that you moved out of the house for your own safety because you did not know the extent of your anger outburst.
No, that is not true.
Mr. Fury, you still do currently live in the back room of the main house, correct?
Correct.
Why?
That's because on the provisions of the protection order, I didn't want to be close to my wife or have contact with her in any way. So I decided to go to the back room so that we can live separately.
Mr. Fury, I put it to you that in accordance with the protection order, you wouldn't have been contravening any aspect so as to entering the shared residence, because nowhere within the protection order was it stated that you are not allowed to enter the residence. All that was stated within the protection order is that you are not to intimidate, assault, insult, or assault the complainant. How do you respond to this?
Well, I decided to go there and live behind because it was a mutual agreement between the two of us. So I thought it's a family matter, and I'd rather like it to keep it private.
Indeed. So it was a mutual agreement, but again, you wouldn't be in contravention with the protection order had you stepped inside the main house.
Sorry?
I said, indeed, you guys came to a mutual agreement, you and Miss Ellen, and I put it to you that you wouldn't have been contravening anything in terms of the protection order, because nowhere was it stated that you'd be contravening the protection order if you were to step inside the house, the main house.
Well, the protection order said so, but then I personally felt that it was inconsistent for me to go to the house and stay with her at the time.
Yes. Okay. So we'll leave it there. You were inconsistent in that regard. Mr. Fury, in your evidence in chief, excuse me. Now, did you ever attempt to resolve this conflict with your wife?
Well, we tried numerous times because we even involved family members to try and resolve this. But because she's always mad at me and blames me for everything that's going on there. So she therefore doesn't want to hear anything but then she always threatens me to call the police. So I decided to keep my distance from her.
Mr. Fury, nowhere within the examination chief of the state or the defense was it mentioned that you guys attended a family consultation so as to reconcile this matter between you two.
Well, that's because she never mentioned it, but I also didn't mention it because we thought it would be resolved, and I deemed it unnecessary to say so because there are some matters that are private, and rather we didn't have to say so because at the end of the day, we're not in good terms.
Now, Mr. Fury, I put it to you that had you made any attempt to reconcile with your wife during this 4-year period, then she would have voluntarily cancelled the protection order against you.
No, that is not true because in her own ways, she's saying to me that she'll call the police and I should never go close to her or anything. She doesn't want to hear it. She's always mad because I'm unemployed. She sees me as this useless person.
Mr. Fury, do you believe there to be any motive as to why the complainant would want to lie under oath regarding the events of 15 May 2021?
Objection.
Objection.
There's an objection. Yes, Mr. Masango.
Counsel is calling for the witness to speculate.
Your
Objection sustained. Objection sustained. I'm not going to afford you an opportunity to reply to the objection, Mr. Van Vieren. The court is in agreement with Mr. Masango. You may proceed, sir.
Okay. As the court pleases, Your Worship. Mr. Fury, during the complainant's examination in chief, she testified that you were the one that assaulted her. How do you respond to this?
That's false because I never saw her because I went to sleep at 9 o'clock in the evening.
Mr. Fury, the complainant further testified that she recognized that it was indeed your voice outside of the main house. How do you respond to this?
Well, I don't know, but then I never went to her to see her. As I was saying, I went straight to bed at 9 o'clock.
Mr. Fury, that your version of events is improbable in that regard. And because of this following matter, and I'm going to ask you this, Mr. Fury, now would you agree with me that had it been one sentence that the perpetrator spoke outside of the house, then the voice authentication would be questionable, correct?
Can you repeat that?
Okay, so would you agree with me then that had it been one sentence that the perpetrator spoke to the complainant, then the voice authentication would be questionable, correct?
Correct.
I put it to you then, Mr. Fury, that there was a dialogue that transpired between you and the complainant. Therefore, we can say with certainty that you are indeed the perpetrator in this matter. How do you
That's
respond
not
to
true.
this?
That's not true.
Mr. Fury, the complainant testified that when she said that she would call the police on you for having contravened the protection order, you then responded by saying that you would show her how much paper is worth, correct?
That's not correct.
Mr. Fury, I put it to you that this alone tells us
Before
that
you proceed, Mr. Van Vieren, do you understand the question, Mr. Fury?
Sorry?
The question that is put to you is that a complainant said or uttered those words. Did the complainant say so or not?
She did not say those words to me because I didn't hear. As I said, I was in my room sleeping.
Mr. Van Vieren, I don't know whether you're going to proceed, because the way the court understood your question is actually you are going back to the testimony that was placed on record. Whether it is true or false will be debated at a later stage, but the way the court understood it is that you have asked Mr. Fury as to whether that is what the complainant or the witness said previously.
Yes, Your Worship, I do understand in that regard, Your Worship. Mr. Fury,
So what the court is saying, the court will allow you to clarify it unless you want to move away from that point and pursue other aspects on your cross-examination.
if I may proceed with the very same question, Your Worship.
You may proceed, sir.
Mr. Fury, the complainant testified in her examination in chief that when she said that she would call the police on you for having contravened the protection order, you then responded by saying that you would show her how much paper is worth. Correct?
You're not correct. That's not true.
Yes, and that would be because you stated that in accordance to your version, you were sleeping at the back room, correct?
Around about 9 o'clock, yes.
Now, Mr. Fury, that is very improbable, because had it not been you, surely you would have heard something. Or if it was another perpetrator, surely you would have heard an altercation happening right in front of the main house.
So, as I explained earlier on, I was unconscious and I was sleeping.
Could you please explain the state of unconsciousness?
I couldn't hear anything. I went fast asleep. I don't know if you understand.
Mr. Fury, again, it's improbable, but the court will make a ruling in this regard. Mr. Fury, I put it to you then as well that when you stated to her that you would show her how much this paper is worth, that this alone tells us that you were well aware and had knowledge of what the complainant was referring to.
Can you just repeat that for me?
I put it to you, Mr. Fury, that when you responded to the complainant in saying that you would show her how much paper is worth, then by saying that, you were well aware and had knowledge of what the complainant was referring to.
At that point in time, like I said, I never encountered an argument with her earlier on, so I don't know what you're talking about. I never was in communication with her.
And again, you never heard anything because you were supposedly unconscious from sleeping.
Yes, I didn't hear anything.
Mr. Fury, I further put it to you that a drunk man's words are a sober man's thoughts. With that being said, and through the words you have said to the complainant, these remarks shows us that you had the intention to assault her.
That is not true.
Now, furthermore, Mr. Fury, how do you respond to Mr. Fury, can you confirm the finding made by the medical examiner who found that the complainant does not take any medication?
Sorry? Can you just repeat that?
Your Worship, if we can perhaps present the accused with, or just present the accused with the J88, so I can allow him to confirm the contents thereof.
I think you must remember, Mr. Van Vieren, J88 already forms part of the record. The court received it earlier as Exhibit A. So in other words, the J88 as well as its contents forms part of the record. If you want to ask certain questions about it, you can do so. But there's no need for the accused to confirm word for word or phrase for phrase the content thereof. It wasn't challenged, it wasn't placed in dispute.
Indeed, Your Worship, but he gave me no answer to that question when I posed the question to him, Your Worship. So perhaps I should rephrase the question.
Or maybe you can just read it and then you can invite him for his comments, huh?
Okay. As the court pleases, Your Worship. Mr. Fury, can you confirm the finding made by the medical examiner who found that the complainant does not take any medication?
Objection.
There's an objection. You may proceed, Mr. Toby.
Your Worship, I want to ask what's the relevance of this question in relation to the matter at hand?
Mr. Van Vieren, do you wish to respond to that?
Yes, Your Worship. So the relevancy of the question is, Your Worship, I'm trying to convey a point that the complainant in this matter is a sober individual. She's not under any alcohol or under any medicine whatsoever. So I'm just leading that point, Your Worship, to prove that she is of sober mind and she can give a clear account of what happened that evening.
The court hear your reply, especially with regards to the fact that the complainant, according to the state, would be in a position to give a clear account of what happened. However, the court is of the view that these are issues that can be left for argument at a later stage when the court has to be addressed on merits. The court is also of the opinion that at no stage was the state of sobriety of the complainant attacked. So the court does not think that there is something that needs to be canvassed, issued, or the accused should be cross-examined on. You may proceed, sir.
As the court pleases, Your Worship. Mr. Fury, how do you respond to the concluding remarks made by the medical examiner who stated that the injury sustained by the complainant was that of a, and I quote, incised penetrative wound on the left shoulder, indicative of stabbing?
My response to that was that I never saw her crying, or I never saw her in any of that medical term, but then I didn't see her in any way, so I don't know.
Your Worship, the state has no further questions for this witness.
Thank you, Mr. Van Vieren. Any re-examination?
Yes, Your Worship, as the court pleases the state, the defense would like to re-examine the witness.
You may proceed, sir.
Mr. Piri, why did you move to the back room?
Because I didn't want to contravene the protection order, and we mutually agreed that a separation from me and her would be best for each one of us.
Were the contents of the protection order clearly explained to you?
Mr. Masango, the court is going to interject there. And what the court is going to say even relates to the question that you've just posed to the witness, the accused in the witness stand. The question put to the accused is why did you move to the back room? This question and this issue was dealt with and it was properly ventilated. The issue with regards to as to whether the conditions contained in the protection order, whether it was clearly explained to the accused person, is this new evidence, sir, on the one hand, or is it something that you want to canvass with the accused person, which was also already canvassed under cross-examination and even examination in chief? The point that the court is trying to make, if there are any ambiguities or things that are not clear or uncertain that cropped up during cross-examination, you are now at liberty and free to deal with those issues. But don't repeat questions, and please don't invite the accused person to testify about things which has already been placed on record. You understand what the court is trying to convey, sir?
Yes, Your Worship.
You may proceed with re-examination if you have any questions, sir.
Mr. Piri, did you know the protection order allowed you to access the house?
Sorry? Can you just repeat that for me? I can't hear you.
Mr. Piri,
Can you hear me?
did you know that the protection order allowed you to access the house?
Yes.
You did.
Yes, I did.
Okay. Around what time did the police come knocking on your door?
It was around about 1:30 in the early morning, 16 May.
Okay. You testified that you were fast asleep and you were deeply unconscious when the alleged altercation happened, as testified to by the complainant. How then did you manage to hear the police knock?
The police banged the door. They were knocking in force, so I told the person to go away as I was sleeping.
How did the person respond, if he did?
He said that he's a police officer and that he has warrant for my arrest.
The court is going to reiterate, Mr. Masango. The court is going to reiterate, out of the 4 questions that you have put to the accused person, only one was a new issue which, according to the court, warranted clarification. All the other issues were placed on record in clear and no uncertain terms. The court is not going to allow you to repeat evidence. If you have other issues that you want to clarify, sir, do so.
As the court pleases, the defense has no further questions for re-examination.
The court does not want to bar you from asking questions. You are allowed to do re-examination, but on issues that you want to have clarified.
Yes, Your Worship, it is well understood.
What do you wish to do, sir?
I have no further questions for re-exam.
Thank you. The accused can then return to the witness box. The defense can call any other witness if they have more witnesses. Mr. Masango.
Your Worship, the defense does not have any further witnesses to call to the stand.
Is that your case, sir?
Yes, Your Worship, we therefore close our case.
Thank you, sir.
As the court pleases.
Defense case.
All right. Good afternoon, Your Worship. My name is Tato Mutingwe. If it pleases the court, the state is ready to proceed with its closing arguments.
You may proceed, sir.
All right. As it pleases the court, Your Worship, in the interest of clarity, the structure of the state's closing arguments is as follows. Firstly, the state begs the court's leniency as it will be reiterating both the matters that are in dispute and facts that are not in dispute, however, that remain relevant to the case, as they constitute facta probantia. Secondly, we'll competently prove with regards to our Leonard Friend's counter-argument in that it was logically fallacious with regards to the issue of identity, as they clearly failed to address issues of great significance throughout the trial. Furthermore, Your Worship, Section 208 of the Criminal Procedure Act is of great importance in proving the complainant's competency in this regard, and therefore it will be addressed adequately by the state. Lastly, all the above mentioned factors will be reiterated for the sole purpose of clearly demonstrating before this court that the state has proven its case beyond a reasonable doubt, as the honors rests with us. To begin the case, Your Worship, the case before the court today is a case of choices. Bad choices that the accused made on the 15th of May, 2021 at 223 2231 extension 7 Ikageng Potchefstroom at about 11:30 p.m. On the day in question, the accused chose to unlawfully and intentionally break the conditions mentioned in the protection order. His conduct clearly contravenes Section 17 of the Domestic Violence Act 116 of 1999, hereinafter referred to as the Domestic Violence Act. He managed to do this by harassing the complainant at her place of rest. Additionally, successfully broke down the door, which was which contravenes Section 7, subsection 1, paragraph E of the Domestic Violence Act. Clearly demonstrating arrogance, Mr. Phiri further continued to intimidate the complainant and disregarded the protection order, which was granted on the 3rd of November 2017. Through his utterance, he clearly demonstrated that he is not fearful of the valid protection order against him, as per the testimony of the complainant that clearly demonstrated the kind of person we are dealing with today. This man has no respect whatsoever for the rule of law, and through his conduct today, he did affirm the credibility of the affidavit written by the complainant to the best of ability, which was written by her approximately 45 minutes after the incident had occurred on the day in question. Furthermore, as if that was not enough, he threatened the complainant with violence by stating that he would show how much paper is worth and that it does not mean much to him. We hope that these utterances by the accused will further corroborate the evidence that the J88 form clearly proved that our case is clear and is clear-cut. May it also be noted by this court that the credibility of the medical practitioner was also not objected by the defense during the trial, which further shows how the state has proven without any doubt the material aspects of the case. This aspect is relevant as it proves that the accused assaulted the complainant with intention to do grievous bodily harm by stabbing the complainant, which was proven based on the documentary finding by the very same J88 that we were submitted earlier on. With regards to the insults, the complainant had to endure during the day in question, it can be logically deduced, Your Worship, that this behavior by the accused was common, hence the interim protection order had to be granted in her favor. In response to the defense argument, which was largely based on identity, the accused that the accused was not drunk was also not adequately addressed by the defense. For emphasis, the state proved that Mr. Phiri's version, which presents an alternative view of what transpired on the 15th of May, could not be reasonably true. These claims are based on how we as a state noted with great concern the emotive and speculative agenda, both by the defense and the accused, as they demonstrated before this honorable court today, in their line of argument and testimony respectively. It became clear that based on the defense argument, they paid little regard to the rules of logic as they were clearly ignorant in this regard. Throughout this trial, both the evidence of the state and the testimony of the complainant in this matter was without any ambiguity or doubt at all. It was consistent and clear. The complainant testified that she was of sober mind on the night in question. Her demeanor throughout this trial must be commended, as she was calm and assertive as to what she testified on the stand about. She felt safe in this virtual courtroom. There was absolutely no ambiguity from her side. The complainant, can I just read that? All right. When she was testifying as
Mr. Motingwe?
Yes, I'm concluding, sir.
Mr. Motingwe, can you hear me?
Yes, I can. Your Worship,
Mr. Motingwe?
Yes, sir. Your Worship. Your Worship, I can hear you now.
Mr. Motingwe, can you hear me?
I was hearing you throughout, Your Worship. I can hear you. Your Worship.
Mr. Motingwe, can you hear me?
I can.
Mr. Motingwe, are you there?
Your Worship, I can hear you clearly, sir.
Mr. Motingwe?
As it pleases the court, Your Worship, this is Advocate Karan. We can hear Mr. Matingwe and we can hear you clearly as well. I'm not sure if you can hear me.
Your Worship, I'm back. Your Worship.
To both teams, we are just trying to reconnect Advocate Adams. If you can just indulge us for a few minutes.
All right, noted.
Motingwe, are you there?
Yes, sir, I am. Thank you very much. May I proceed, sir? May I proceed, Your Worship? Your Worship? Your Worship? Can you hear me, Your Worship? Okay, I'll proceed. Okay. Through the utterance,
Just
through
before
the
you proceed, Mr. Mutingwe, just give us a minute.
Right.
Advocate? I can see myself, I see all of you, but I don't hear Mr. Motingwe.
Advocate Adams, can you hear us?
I've unmuted myself, can you hear me?
Yes, can you hear me?
Your Worship?
Matingwe?
Mr. Matingwe, can you hear me?
Can Your Worship, can you hear me?
Yes, I can hear you loud and clear, sir. What I'm going to ask you to do is if you can just recap, at some stage you were dealing with the issue of identity and you were also referring to the accused version. Can you please pick up from there, please, sir?
I will do that, Your Worship. Thank you very much. Okay. There we go. Can I just start with, I think, giving a response now? It'll correlate with what was mentioned. Is that fine with you, Your Worship?
You may proceed, sir.
Your Worship. Now, in response to the defense argument, which was largely based on identity, the issue that the accused was not drunk was not adequately addressed by the defense. For emphasis, the state proved that Mr. Pierce's version, which presented an alternative version or view of what transpired on the 15th of May, could not be reasonably true. These claims are based on how we as a state noted with great concern the emotive and speculative agenda that both the defense and the accused demonstrated before this court. Today, in their line of argument and testimony respectively, it became clear that based on the defense argument, they paid little regard to the rules of logic, as they were clearly ignorant. Throughout this trial, both the evidence of the state and the testimony of the complainant in this regard was without any ambiguity or doubt at all. It was consistent, clear, and clear. The complainant clearly testified that she was of sober mind on the nights in question. Her demeanor throughout this trial must be commended, as she was calm and assertive to what she said in this virtual courtroom. There was absolutely no ambiguity from the side of the complainant when she was testifying as to what had happened on the day in question. The accused's testimony was, however, logically fallacious in that he failed to competently provide an alternative view as to what had transpired on the day. Enough, Your Worship, it was that. However, taking into account that both the complainant and the accused have been married for years, it is undoubtedly true that based on the voice of the complainant's husband, surely she ought to hear and recognize instantaneously the husband. Further uncertainty was noted with regards to the testimony provided at the beginning by the state that he was unemployed, and then further he contradicted himself by saying now he was employed, and then contradicted himself saying now he's unemployed. We'll move on to this segment of Section 208. Section 208 of the Criminal Procedure Act 51 of 1977 provides that the conviction may follow on the evidence of a single witness. However, the cautionary rule pertaining to the evidence of a single witness should apply, as it is a requirement that the trial court should have been satisfied with that the complainant was both true and reliable. Indeed, Your Worship, it has been undeniably clear that the complainant in this regard was both truthful and reliable, as she competently testified to this effect. However, that cannot be said about the accused version. Moreover, Your Worship, you prove the accused guilt with certainty. We are aware that the defense will desperately bring a counter-argument that attempts to refute what the complainant has asserted before this court. However, we've resiliously pleaded with this court to make its ruling solely on the material aspects of this case, which the state has competently proven which the state has proven beyond a reasonable doubt and not just doubt. Additionally, it became evident that based on the merits of the case, the state clearly demonstrated the unlawful conduct of the accused. On the contradiction that the defense desperately alleged and tried to prove today, I refer them to the case of the state versus Souls and others, 1989, Volume 3, South African Law Report 172, where the court held that there is no rule or formula in assessing the credibility of a single witness. The alleged contradiction that the defense is making reference does not address the material aspect of this case adequately. In fact, there are no material contradiction and no inconsistency in the state's case. I draw this honorable court's attention to what the court in R versus Abdoham, 1954, Volume 3, South African Law Report 163, where the court decided that a court is entitled to convict on the evidence of a single witness if it is satisfied beyond a reasonable doubt that such evidence is true. We as the defense believe we have discharged that honest, Your Worship. Can I just take a breather? Sorry, Your Worship. In closing remarks, I draw this honorable court's attention to the preamble of the Domestic Violence Act that recognizes and speaks directly to the social ills that is brought by the aforementioned. The Domestic Violence Act sees and addresses the need of protecting the most vulnerable members of our society. Your Worship, it became crystal clear today that not only does Mrs. Peary truly fit the description of vulnerability, however, she's also worthy of being protected in the spirit of upholding the Domestic Violence Act. The accused is clearly a frail woman who was ironically asked by the defense why she was afraid to open the door in the middle of the night. Through advocating for her, in our response to this not so wise question, which was brought earlier by the defense, in a country where it has one of the highest rates of violence against women and girls in the world, and a femicide rate that is 5 times that of the global average, with an estimated 12 in every 100,000 victims affected each year, according to data provided by one.org, she had to be afraid. As for him being unconscious, the court will draw an inference in this regard. Moving on, Your Worship, we have the opportunity to rectify the social ills today. The accused was supposed to provide consortium, and he failed in his duty, and he then became an enemy from within. Your Worship, we earnestly believe that there is an inseparable association between listening and speaking. In this regard, we as a state, and hopefully my opposing learned friends would agree with us in that we heard intensely the version of a woman who was vulnerable against a vicious man who, under the auspices of alcohol, attacked his wife. He further failed in his duty to protect her. The state, therefore, with great humility, prays that this honorable court will uphold the duty to protect the vulnerable and find the accusers guilty of contravening Section 17 of the Domestic Violence Act with aggravating circumstances. I thank you, Your Worship.
one university experience that I can single out as an absolute favorite, it is the law faculty's annual mock trials. The mock trial experience gave me the opportunity to build confidence, or what I call court confidence, by exposing me to court procedures and etiquette, and I cannot wait to put what I've learned into practice next year when I commence with my practical vocational training.
Good day everyone, my name is Teboho Madiwo and I am a member of the previous winners of the mock trial competition for 2018 and 2019. What the mock trial taught me and what it means to me, that it taught me the art of arguing. So it taught me how to understand the fundamentals of arguing. What I would say is also changed my life in the way I approach law and in the way I would pick my path going into the future. So now, this is not gonna only teach you to argue, but it's gonna teach you what type of lawyer you wanna be. Once again, I would like to congratulate you, Advocate Quran, for the 10th anniversary of the mock trial, and have a good day.
I would not swap my time in the Juta mock trials for anything. Of course, I am happy to have learned many of the technical aspects of a trial, but the experience itself meant a lot of value to my evolution. It reminded me what I enjoyed about the law because of the pleasure I found in preparing for trial with my team. You are forced to come up with creative solutions to each case, but you're also put in a position where you have to try and outthink your opponents on what they might bring to court. The opportunity to present your case in front of judges with so much stature also has done a lot to boost my confidence in the prospect of practicing the law. I think by participating in the mock trials, you not only get to refine skills that other students won't get the opportunity to until they actually work, but you also get to grow more as a person with ambitions in this field.
First of all, a huge congratulations for running this initiative for the last 10 years. I can definitely say that I have learned a lot in my time from these trials when I was a former student at the Northwest-Universiteit, and it definitely bridged the gap for me between theory and the practical world. I was somewhat prepared when I walked in to court, as well as when I did my articles. I knew I could fall back on what I was taught in these mock trials. So I can definitely say that it is an incredible initiative. Please keep it going.
The NWU-Juta mock trial competition brings back some great memories where I met many amazing people and learned some valuable practical knowledge in the 3 years that I had the privilege of taking part. One of the biggest takeaways I have from participating is the strict emphasis that was placed on working together as a team. This has really given me insight into how valuable it can be to have input from multiple points of view when preparing a legal argument. As a student, the competition was something to look forward to every year, and team building exercises and workshops brought together a community of very competitive individuals from our faculty and gave us a deep insight into managing the dynamics of different personalities. This year marks the 10th anniversary of the competition, and I hope to see it grow exponentially. A huge thank you to Advocate Quran and all of those involved in making this a possibility every year. Thank you.
Hi everyone, I'm Marijke van Jaarsveld and I was part of the team that won the 2016 Juta mock trials. I'm currently practicing in Gauteng as a labor law attorney. I can honestly say that the time I spent participating in the mock trials holds some of my fondest university life memories. I had the privilege of spending my time with smart, creative and funny individuals. It helped me build my confidence, and looking back, I made some really good friends. So, if you're considering whether or not to participate, I really would suggest that you do. Because even if you don't win, you'll still be a lot of fun.
participated in the Juta mock trials during 2015 and 2016, and I can at the outset recommend it to each and every law student to get involved and to participate in the Juta mock trials. The Juta mock trials taught me, or at least helped me, to improve my listening skills, my communication skills and teamwork, which are skills that is not only required in a courtroom but also in everyday life. I believe that the Juta mock trials is a great initiative.
I've participated in the Juta mock trials during the years 2017 and 2018. The Juta mock trials were quite difficult, yet filled with enjoyable experiences. The Juta mock trial have boosted my confidence, and I will truly and most definitely encourage all students to participate in the Juta mock trials.
I had the privilege of participating on the Juta Northwest-University Intercampus Criminal Mock Trials during the year 2017 as a finalist, and won it as a tutor during the year 2018. It is through initiatives such as the Juta Northwest-University Intercampus Mock Trials that one gets to learn the practical part of law. Through Juta, I was able to learn how to deal with witnesses, the importance of understanding facts, your law, and applying the law to the facts. I was able to get a Section 174 discharge on my first trial at the district court, and on my, surprisingly, yes, on my first trial at the regional court as well. You get to see the importance of having initiatives like this one, that they sharpen one skill and improve and build your confidence, your research skills, and understanding of the law.
Participated in the Juta mock trials in 2016 and 2017. In 2017, I was chosen to be part of the NWU third year's Juta mock trial team. If it was not for the Juta mock trials, I would not have been so confident in knowing that I would be able to become an advocate. I always thought that is what I want to do, but sometimes you need that extra nudge in the right direction, and that is what the Juta mock trial was for me. The mock trial training, so I'm so grateful for having been part of the experience, and if you're thinking about doing it, do it. It's an amazing experience.
You may proceed, defense.
Your Worship, if it pleases the court, the defense would like to proceed with its closing argument.
Please proceed.
As the court pleases. The matter in dispute is of assault and the contravention of the protection order, not the events that took place in 2017. The protection order can only be contravened in the following ways: verbal abuse and harassment of the... Yes. Can I proceed?
Yes, you may.
The protection order can only be contravened if the following occurs: verbal abuse and harassment of applicant, and any act of domestic violence of which none of this happened. The accused was not placed at the scene when the alleged incident took place, and there is no evidence to corroborate that he was indeed at the scene. The elements of assault herein are: conduct which results in another person's bodily integrity being impaired, or the inspiring of a belief in another person that such impairment will take place. This element is not present because The conduct part of it could not be proven by the state that the accused was indeed the attacker in the alleged incident. The second and third elements, which are lawfulness and intention, are also not present in this matter because the state could not prove that the accused was the attacker and could also not place him at the scene. The accused testified that the complainant blames him for everything that goes wrong in the yard. Therefore, the complainant saw that this would be a good riddance. In her statement, the accused doesn't know who attacked her because one moment she refers to the attacker as her husband and the other moment refers to the attacker as the attacker, which proves that she is confused and doesn't know who attacked her. And since while she blames the accused for everything that goes wrong in the yard, she saw fit to blame the accused for this incident as well. This case is driven by anger of the complainant for the accused, as the accused testified that his wife is mad at him for not having a job. This case is also based on speculation because the state could not prove anything said by the complainant, along with the J88, that does not prove that the injuries she sustained were inflicted by the accused. These injuries could have been caused by anyone. In terms of Section 208 of the Criminal Procedure Act, a court may convict an accused based on evidence of a single witness, provided that such a witness is a single witness and is deemed competent. We submit that the complainant is an incompetent witness because she contradicted herself. She wasn't sure who her attacker was. One moment she referred to the attacker as her husband, the next she referred to the attacker as the attacker. The evidence provided was also not enough to place the accused at the scene. She testified that at the time she heard the banging at the door, it was dark in the house, but she claims that she saw the accused because of the shadow she saw. She testified that she could not see the object used to attack her, but how could she have not? She testified that she could not see the object used to attack her, but how could she have seen a shadow, but not a shining object used to stab her? The complainant also testified that the keys fell down, but she did not mention this in a statement, which now creates uncertainty in this case. There is no evidence to prove that the accused was drunk because the complainant heard a slurred voice and concluded that it was the accused who was drunk. Recognizing someone's voice while being pumped up by adrenaline could mean that she's lived with him so long that it would be her first response to think that it was him without being sure. The complainant testified that the accused hasn't contravened any of the provisions of the protection order since 2017. Why would he start now? This is just an aggravated woman that's angry that her husband is unemployed and saw an opportunity to misuse the protection order. He has access to the house. Why would then the accused break down the door? A person cannot be convicted merely because the complainant thinks it was her husband's voice. No evidence can prove that the complainant's testimony is true. It cannot be deemed true that she managed to identify the attacker to be the accused, because she testified that the attacker came from behind, which corroborates our contention that she did not see the attacker's face. In light of the highlights made above, we therefore pray that this court finds the accused not guilty of assault and the contravention of the protection order. To set aside the protection order in terms of Section 13 of the Domestic Violence Act, because the complainant is using the protection order in malafide.
Thank you. Any rebuttal from the state? No rebuttal from the state?
Your Worship, we do have a rebuttal. Mr. Matingwe is just trying to connect at the moment. He's having also internet errors.
Thank you.
Sorry.
Please proceed, Mr. Matingwe.
Yes, thank you so much. I really apologize for the inconvenience. Your Worship, in rebuttal, I'll just, firstly start that say it was quite a mammoth task delivering this rebuttal. However, look, we really did prove our case beyond a reasonable doubt, and in particular, the issue of identity. We say this because, clearly, given it's not logically sound that a person who has been married, who they've been married for so long, is now unable to identify that very same person. I think that it really bothers us as a state. And for those reasons, it became clear that the state has proven their case beyond a reasonable doubt. We thank you, Your Worship. Thank you.
Thank you. The court will adjourn and we will then return with the verdict from Advocate Adams.
If there is one university experience that I can single out as an absolute favorite, it is the law faculty's annual mock trials. The mock trial experience gave me the opportunity to build confidence, or what I call court confidence, by exposing me to court procedures and etiquette, and I cannot wait to put what I've learned into practice next year when I commence with my practical vocational training.
Good day everyone, my name is Teboho and I am a member of the previous winners of the mock trial competition for 2018 and 2019. What the mock trial taught me and what it means to me, that it taught me the art of arguing. So it taught me how to understand the fundamentals of arguing. What I would say is also changed my life in the way I approach law and in the way I would pick my path going into the future. So now, this is not going to only teach you to argue, but it's going to teach you what type of lawyer you want to be. Once again, I would like to congratulate you, Advocate Quran, for the 10th anniversary of the mock trial, and have a good day.
Trials for anything. Of course, I am happy to have learned many of the technical aspects of a trial, but the experience itself meant a lot of value to my evolution. It reminded me what I enjoyed about the law because of the pleasure I found in preparing for trial with my team. You are forced to come up with creative solutions to each case, but you're also put in a position where you have to try and outthink your opponents on what they might bring to court. The opportunity to present your case in front of judges with so much stature also has done a lot to boost my confidence in the prospect of practicing the law. I think by participating in the mock trials, you not only get to refine skills that other students won't get the opportunity to until they actually work, but you also get to grow more as a person with ambitions in this field.
First of all, a huge congratulations for running this initiative for the last 10 years. I can definitely say that I have learned a lot in my time from these trials. when I was a former student at the Northwest-Universiteit, and it definitely bridged the gap for me between theory and the practical world. I was somewhat prepared when I walked into court, as well as when I did my articles. I knew I could fall back on what I was taught in these mock trials. So I can definitely say that it is an incredible initiative. Please keep it going.
The NWU-Juta mock trial competition brings back some great memories where I met many amazing people and learned some valuable practical knowledge in the 3 years that I had the privilege of taking part. One of the biggest takeaways I had from participating is the strict emphasis that was placed on working together as a team. This has really given me insight into how valuable it can be to have input from multiple points of view when preparing a legal argument. As a student, the competition was something to look forward to every year, and team-building exercises and workshops brought together a community of very competitive individuals from our faculty and gave us a deep insight into managing the dynamics of different personalities. This year marks the 10th anniversary of the competition, and I hope to see it grow exponentially. A huge thank you to Advocate Karan and all of those involved in making this a possibility every year. Thank you.
Hi everyone, I'm Marijke van Jaarsveld and I was part of the team that won the 2016 Juta mock trials. I'm currently practicing in Gauteng as a labor law attorney. I can honestly say that the time I spent participating in the mock trials holds some of my fondest university life memories. I had the privilege of spending my time with smart, creative and funny individuals. It helped me build my confidence, and looking back, I made some really good friends. So, if you're considering whether or not to participate, I really would suggest that you do. Because even if you don't win, you'll still be a lot of fun.
I participated in the Juta mock trials during 2015 and 2016, and I can at the outset recommend it to each and every law student to get involved and to participate in the Juta mock trials. The Juta mock trials taught me, or at least helped me, to improve my listening skills, my communication skills and teamwork, which are skills that is not only required in a courtroom but also in everyday life. I believe that the Juta mock trials is a great initiative.
I've participated in the Juta mock trials during the years 2017 and 2018. The Juta mock trials were quite difficult, yet filled with enjoyable experiences. The Juta mock trial have boosted my confidence, and I will truly and most definitely encourage all students to participate in the Juta mock trials.
I had the privilege of participating on the Juta Northwest-Universiteit Intercampus Criminal Mock Trials during the year 2017 as a finalist, and won it as a tutor during the year 2018. It is through initiatives such as the Juta Northwest-Universiteit Intercampus Mock Trials that one gets to learn the practical part of law. Through Juta, I was able to learn how to deal with witnesses, the importance of understanding facts, your law, and applying the law to the facts. I was able to get a Section 174 discharge on my first trial at the district court, and on my, surprisingly, on my first trial at the regional court as well. You get to see the importance of having initiatives like this one, that they sharpen one skill and improve and build your confidence, your research skills, and understanding of the law.
participated in the Utah mock trials in 2016 and 2017. In 2017, I was chosen to be part of the NWU third year's Utah mock trial team. If it was not for the Utah mock trials, I would not have been so confident in knowing that I would be able to become an advocate. I always thought that is what I want to do, but sometimes you need that extra nudge in the right direction, and that is what the Utah mock trial was for me. The mock trial training. So I'm so grateful for having been part of the experience. And if you're thinking about doing it, do it. It's an amazing experience.
Well, at a more personal level, I've learned quite a number of skills, values, lessons through my involvement in this program or initiative. Two stand out among those lessons. The first is confidence, the ability to stand in front of the people, articulating yourself, addressing them boldly, firmly, confidently, without any sense of self-doubt. That is among those lessons. I learned to be confident through my involvement in this competition. The second is teamwork. So confidence and teamwork remains to be the most fundamental lifetime lessons that I have learned through my participation in this competition. The Juta Intercampus Criminal Mock Trial of the Northwest-University Faculty of Law is a great initiative. In that note, I would really want to commend the Northwest-University Faculty of Law for having developed and maintained this great initiative. It is very progressive, it is very insightful, and over and above all, it continues to inspire, capacitate, and empower those students who get the privilege of participating in it.
I participated in the mock trial competitions from 2012 to 2014. I learned quite a few valuable life skills from the mock trials. The first would be that teamwork is always better than struggling alone. The second would be to be able to think on your feet in any situation. After I graduated in 2015, I started my articles at a law firm that expected me to attend court on a daily basis. I was so grateful for the experience that the mock trials gave me, because I was so much more confident than most other candidate attorneys. And today I'm the director of my own law firm. We specialize in criminal law and litigation. So never underestimate the little experience that the mock trials can give you.
I took part in the Utah mock trials in 2014 and 2015, and my team and I were successful in 2015 and won the overall competition. I believe it's a fantastic idea, and it does teach you quite a few valuable skills. I personally have learned a lot about litigation and gained confidence in litigating in court, to such an extent that I'm currently the head of the litigation department, and I would encourage every student that is interested in litigating in court one day to take part in this competition.
Hi, I'm Mafam Zamo, and I'm an NWU alumni, currently an admitted practicing attorney in our litigation department. One of the things that I absolutely love about the NWU law faculty is the manner in which it just prepares us for anything that we take on after varsity. One great example being the mock trials, which I participated in 2015. I learned so much from the mock trials. For someone who's currently, in the litigation department, constantly going to court, I have learned court etiquette from the mock trials. It boosted my confidence. It really just assisted me in how to take on each matter that goes on trial. I do not regret ever participating in it because it really was such a great experience that is contributing so much to what I'm currently doing.
Hello NW community, my name is Davin Olin and you may recall my face from the 2016 finals and the 2015 semi-finals of the NWU-Juta moot court competition. To me, the competition was a unique opportunity to really flex our legal minds in practice, and I annually encourage all law students to make use of this brilliant platform to hone in on their litigation skills. To all the undergraduate spectators, I encourage you to make use of this platform as it has a significant impact on one's approach to law. And to this year's finalists, best of luck.
The pace has never been faster. The bar never higher. Good enough has never meant less. Technology has redefined every aspect of our lives. How we learn, work, and engage with the world and those around us. We need knowledge to survive, tools to take action, communities to be strong and flourishing, practical insights, innovative strategies, and digital transformation. Open the doors to success. Take a risk. Learn a skill. Start something new. Transform South Africa for a global digital tomorrow. Juta, tools for lifelong learning and apps to grow your business. Inspiring possibilities together.
Good evening, everyone, and thank you for joining us and bearing with us throughout our connectivity issues. I'm sure we are not strangers to that these days. It's now an honor for me to introduce Advocate Steve Alcock from Juta, who's going to share a few words with us. Advocate Alcock, the floor is all yours.
Good evening, and thank you for having me as part of the evening's proceedings. On behalf of Juta and myself, I'd just like to say congratulations to everyone who participated and also organized what I think is a successful event. To the winners when they're announced, well done on your achievement. I've been privileged in my career to have worn many hats. Two such hats included advocate and guest lecturer in legal practice. And a lot of the effort and time goes into preparation of and for a mock trial. and you're all to be commended on your dedication. To all the participants, it was wonderful listening to your arguments. Your preparation truly paid off, and you should all be proud of what you've achieved. Trial advocacy has always had a special place in my heart. After leaving practice to move to Juta Publishing, I was given the opportunity to apply my experiences in conceptualization and preparation of works aimed at assisting students and young practitioners to learn the valuable skills required to apply what they've learned once they're in practice. And amongst those titles I've published over the years are ones aimed specifically at trial preparation and presentation in court. And the reason is because these are hard skills to master. Trial skills are essential to understanding the march of the litigation process and to diligently prepare a proper case on behalf of a client. And your legal options and prospects, after all, depend on a proper understanding of the factual and legal matrix of your case, as well as all the options available to a party that is going to go to court. So this evening has truly been inspiring for me to see your well thought out and prepared presentations. And I look forward to hearing the judgment. Thank you.
Thank you so much, Advocate Alcock. It's really appreciated, and Juta has been part of our journey since 2013, and it's really contributed so much towards the development and especially those skills of the students. Please allow me now to just give a short vote of thanks before the judgment. We will be awaiting Advocate Adams back shortly. First, from my side, this all started as a vision. I want to thank our Heavenly Father for making this all possible, even throughout these difficult times. Advocate Adams has been part of this journey since the very first trial. He's also been the presiding officer at the very first mock trial of the NWU, and it all just seemed fitting that he's also the presiding officer at the 10th anniversary. Advocate Adams, thank you not just for today, but also for the past 10 years. You've always encouraged our students to do their best, and you have also managed to also kind of leave a legacy as students also remember what you have taught them during this process. I want to thank the executive team, faculty members, the NWU staff who joined us online, as well as the dignitaries mentioned by our executive team. Then, of course, I already thank Juta, for buying into this initiative and for your support. You have truly made this an even more exciting journey than it already is. I want to thank also from support staff and also Mrs. Annelie Pfeiffer, Mrs. Sarita Marie, thank you. And then also from the Law Clinic side, Mrs. Henry Barnard and Ms. Bianca Insolent. We really do appreciate that the support that you've given us and the teams throughout this journey. To all the tutors, and we had a section where we were supposed to hear from the tutors as well, and but due to the already kind of stretched out program, I thought I would just maybe thank them, each and every one of them. That's Advocate Zake and Mrs. Burns from the Van der Bijlpark campus, and Mr. Maren Stoffels from the Potchefstroom campus. Without you and without your assistance, this would not have been possible. Thank you for your patience, for your efforts, and putting in that extra mile to develop our students. And I think that we can really be proud of them. Of course, I think I want to make a special mention also of the assistance that Ms. Celia Lawrence have basically provided to us, constant contact with them, in communication with them, arranging all the sessions and administrative, all the appointments and the meetings and scheduling she's done. Thank you so much, Celia. Thank you is not enough, but we do appreciate everything that you are doing for the students. And we also appreciate your passion for student development. Then, of course, also Ms. Magistrate Winnie Malani, Acting Regional Court President of Northwest, who did a stellar job as presiding officer during our semi-final. Ms. Malani, thank you so much. Your contribution was really, can never be underestimated. We want to thank you for the value that you've added to our students, and also for your patience throughout the whole day. It took literally from 8 o'clock in the morning until late in the afternoon for us to get through the semi-final. So thank you so much for that. Of course, we also make use of our first years, mostly as witnesses and the accused and the complainant. Thank you for joining us, and thank you for your eager and your willingness to assist us in the process. Thank you, of course, to the family, the friends, and all the people that support the students throughout this. They do not get extra credit for this. This is not for any assessment contribution. They do this because they love the law. And we really do appreciate that support that you gave the students throughout the past few weeks. Of course, thank you also to MSM Production, SF and his team, for making all this possible. For the most of it, I think it went really well, and we are grateful to also be partnering up with you for this initiative. And then, of course, last but not least, all the students that participated and registered for the competition. For this year, we had about over 140 students who registered for the competition, and seeing that it was all online for the first time ever, and it was cross-campus, and students had to use their own data to do the elimination rounds. It really is just indicative of their eager and willingness to learn, and also their love of the law. And we really want to salute you and thank you for keeping this competition alive. And now, finally, I also want to say, because it's since 2011 up until now, thank you. Without you, we would not have been here. We love to see you grow, and we are so proud of what you have accomplished and what you are still going to accomplish in your careers. And we look forward to seeing that. Don't be strangers. Please check in with the faculty. We would love to hear from our alumni. And also to all the personnel, you for sacrificing your time, and also your love for student development in general, by just, sacrificing your time to do the after hours, time consuming elimination rounds, and also going through the weekend workshops and so on. It is really appreciated. And I think that you will also find that when students do give us feedback, that it is evident in there. And that is all from my side. And I think that in a few minutes, the court will be back in session. And I think we do have Advocate Adams online. So the next up will then be the judgment. Okay, if you can just give us 5 seconds.
The accused in this matter, Mr. Piri, was charged with contravening a protection order which was issued in 2017. The accused is alleged to have contravened this protection order on the day as reflected in the charge sheet. The state's case consisted out of a single witness which was called to come and testify. The evidence is the wife to the accused person. This witness testified that on the day in question as reflected in the charge sheet, the accused came to the main house, the shared residence. The accused tried to gain entry. The accused dropped his key. The accused then started to bang at the door. The accused demanded to enter the house. The complainant, the witness, asked the accused to leave. The witness reminded the accused person about the protection order which was enforced and which existed at a point of time, to which the accused would have answered that he will show the witness and that the accused is not afraid of the protection order which was in existence at that point. The court will deal with the issue of credibility as well as the way the witness testified shortly. The court just quickly wished to reflect on the evidence which was tendered by the accused person. The accused testified in his own defense. No witnesses were called. It is the version of the accused person that on this day, this particular day, around about 9 o'clock, 9:30, the accused went to his dwelling, which he has erected for himself in the backyard. He went to sleep, and according to the accused, he does not know anything about what would have happened at the main residence, the fact that someone would have tried to gain entrance. And according to the accused, he was arrested by the South African police when they banged at his door round about 1:30 in the morning. The court now wished to turn to the evidence tendered by the state, and the court wished to analyze the evidence. There are two cautionary rules that the court needs to bear in mind when the court analyzes the testimony tendered by the state witness. The first issue that the court is mindful of is the fact that a single witness was called. The court is reminded of the provisions of Section 208, which indicates that such a witness testimony can only be accepted and can only be relied upon if it is clear and satisfactory in every material respect and aspect. The court observed the witness in the witness stand. The court is of the opinion that the witness was frank, the witness was open, the witness answered the questions without hesitation, and according to the court's observation, frankly so. The witness did not deviate materially from the statement that she would have made when she went to the police station. This statement was also put before the witness for purposes of cross-examination. And it is the court's opinion, even though that there were valiant attempts from the defense's side, this witness did not deviate from a statement when it came to material aspects and the merits of the case. The witness was calm, as the court already indicated, and the witness didn't buckle under cross-examination. The court was very impressed with the way the witness testified. The court could also not detect any ulterior motives as to why the witness would have made false claims and pressed false charges on this particular day. One needs to remember that this particular protection order was sought, was applied for, and was granted in 2017 already. A number of years went by, number of years passed, and one needs to ask yourself, why would a complainant wait for so long if she wanted to lay false claims against the accused person? One needs to compare and contrast the testimony which was tendered by the complainant with the version given by the accused person. And the court, right at the outset, must indicate that the accused did not make such a favorable impression on the court. There were a lot of improbabilities which were glaring in the version of the accused. Some of these improbabilities were highlighted by the state during cross-examination. It was, for instance, put to the accused person as to why and how it is possible that he did not hear the commotion which should have taken place, not very far from where he was fast asleep, if it was another person who tried to gain access and entrance into the house. The accused did not really have an answer to this question. When the accused was asked as to why it was then possible for him to hear when the police were knocking at his door, he indicated that the police was banging at the door, and that woke him up from his slumberance. The other issue, at the outset, the court indicated that there are two issues that the court needs to consider. The other issue which the court needs to take into account and which the court needs to be mindful of is the issue of identity. It must be remembered, and case law is very clear on this aspect, that even an honest witness can make a bona fide mistake. It is therefore possible that inasmuch as the complainant can come across as someone who is truthful, someone who played open cards with the court, there is that possibility that she could have made an honest mistake with regards to the identity of the accused person. As was said in case law in the past, the issue of identity is a very uneasy horse to ride. Honest witnesses can make mistakes. And the court once again needs to approach this testimony and evidence with the necessary caution, being alive to the issues at play. In this respect, the court wished to point out that when the witness testified, she indicated that she heard this person trying to gain entrance speaking, but the speech was slurred. The person was under the influence of alcohol, and as a result of that, his speech was affected. The witness at some stage said that the words which were uttered are the very same words which the accused would utter from time to time. The witness further testified that she has been married to the accused for a number of years, and as a result of this, she is in a position to hear the accused's voice and to know that it is him who on this particular day is the one who tried to gain entrance and who had a conversation with her. At some stage it was also put to her that if it was one sentence, maybe there could be doubt. It was pointed out that there was a dialogue that took place, some communication that took place. The court wished to point out that this further strengthens the possibility that there is no mistake, no erroneous identification that took place with regards to his voice. The defense pointed out that there was no facial identification that took place. It seems to be a common cause that the area where the incident took place was not well lit. In fact, it was dark. And the complainant or the witness, once again, even on these aspects, things which were not very favorable to the state, played open cards, and she indicated that she couldn't see clearly, but she could make out certain lines of objects and so on. And she said, in so many words, that yes, when it comes to facial recognition, she would not be in a position to say that it was the accused. However, the court is even satisfied and convinced on this aspect when it comes to identity, that the witness did not make a mistake. The court is of the opinion that it was the accused's voice that the witness recognized on this particular day. And even if one read between the lines with regards to the words which were uttered in respect of the protection order, it increases the probabilities that a person who tried to gain access on this particular day was the accused person. The state referred the court to case law in this regard. The court is grateful for the case law that the state referred to, and the case law is very much in line with the points that the court has already pointed out. It is therefore the court's opinion and view that the state managed to prove its case beyond reasonable doubt, beyond all reasonable doubt. The court looks at the evidence standard by the accused person, and the court is of the opinion that there was no serious challenges with regards to the evidence placed on record from the state side, and as such, the accused is convicted as charged. Mr. Prosecutor.
Yes, sure. We are very much grateful for the ruling, Worship. We are very, very, very glad to hear that. This is in the interest of justice, and she really does deserve this justice. Thank you very much, Your Worship. We know the judgment. Thank you.
May I then assume that we are not going to move over to the sentencing stage, Mr. Motingwe, if you're now thanking the court for the verdict?
My Leonard colleagues could come in and interject and assist me in that regard, Your Worship. Please. Counsel Raymond.
Your Worship, the state would like to now proceed to the sentence of the accused in accordance with the judgment made.
You may proceed, sir. Mr. Van Vieren?
Your Worship, could you kindly just please give him a brief, momentary relief that he just quickly consults with the rest of the team and will return. A couple of seconds. And
Mr. Motingwe, if we didn't prepare ourselves on this stage and phase of the trial, it is fine. We can leave it at that, because obviously if we move further, that means that the defense will also have to prepare themselves, and then you're going to have to prepare yourself on speed. So if that was not part of your preparation, I think that is how far we will take it.
Fully wasn't, and thank you, Your Worship. We really appreciate you. Thank you very much, Your Worship. Thank you for the ruling. We appreciate it. Thank you.
Thank you, Mr. Motingwe. Advocate Koran, I don't know whether I can proceed and announce the winners according to my take, or whether there is anything that you would like to do, anything you would like to say before I do so.
Thank you, Advocate Adams. I think I will leave it to you to announce the winners of the mock trials 2021.
Okay. Colleagues, allow me first of all to congratulate all of you. It was very clear and evident that a lot of preparation went into what you had to do today and tonight. It is a pity that we had a few challenges that we had to overcome. But during my conversation with Advocate Koran earlier, I've indicated to her that these are the realities that we also live in, and even in real courts, where we are busy with real trials, you would know that we have to make use of these virtual platforms. It's just a pity that we have lost some time. But as I've said, I could see that a lot of preparation went into it. I am extremely impressed with the way you have presented your sides, your cases, whether you were on the side of the state or whether you were on the side of the defense. I am impressed, really impressed. And I'm also looking forward, this is from me personally now, I'm looking forward and I hope that I will see some of you hopefully not in the distant future, knocking at our doors as the NPA to come and work as prosecutors. Those of you who will pursue a career on the other side, in the private sector, everything of the best with all your endeavors. Not only was I requested to give judgment in this case, but I also have the task of indicating and announcing the winners. It's a pity that there can be only one winner. I've made up my mind when it comes to the team that, according to me, is the winning team. And as Advocate Koran indicated, it has got nothing to do with the judgment itself or the way the trial unfolded. The mere fact that there is a conviction does not mean that the state is the obvious winners. But having said that, and in line with the judgment, may I indicate that from my side, the state in this particular instance, according to me, is the winning team. And these are my reasons. I see some of us are celebrating already. It is a good thing that we are on mute. These are my reasons. I was particularly impressed with the way the witness was led. It was a rocky start in the beginning, but I think the prosecutor recovered. And a lot of detail was placed on record with regards to what would have happened on this particular day. I also think a sterling job was done with regards to cross-examination. He's not a person who has done it, or if he was asleep inside. I'm looking at the way the state went about dealing with the documents and so on, the J88 and the other documents which were handed in. I was also obviously impressed with the defense at certain stages. I think the defense made a valiant attempt to come up with a defense in this particular instance. And it's not just about, how the accused testified and the fact that the accused is now convicted. As I've said, you could see that the defense were also very much prepared. I think the cherry on the cake, or the thing that ultimately persuaded me that the state should be the winners in this particular instance, was the address on merits. I think it was well executed, well articulated, the case law and everything very much coherent. And from my side, as I've said, congratulations to the team. You really deserve it. Thank you, Advocate Koran.
Can I go on?
You may proceed. Thank you, ma'am.
Thank you, Advocate Adams. Much appreciated, and well done to both teams. Congratulations to NWU3. I can now announce that the winning team is NWU3. Third year's NWU team, congratulations. And I will also now take the opportunity to announce the Facebook photo competition. And it also just happens that the very same group also won the photo competition. So well done to Mr. Raymond van Pieren, Lutando Swartz, Jacob Masumpa, and Tato Matingwe for also winning the photo competition. Thank you very much, Advocate Adams, much appreciated. And we are really grateful that we could finalize this hearing today, although sentencing is postponed. Let's indicate that. Congratulations once again, teams, and thank you to all the viewers. And we hope that you have a wonderful evening further.